Okay. Constitution, week 3. We'll be looking at the rule of law and a couple of cases related to it, where we'll be talking about how to interpret the Constitution and looking at a couple of cases that relate to that. We'll be looking at the pith and substance of statutes, what is necessarily incidental. We'll be looking at the double aspect doctrine and some language of the law. So the rule of law. According to Manitoba Language Rights case, the rule of law is supreme over officials of the government as well as private citizens, and it should not be an arbitrary power. It requires the creation of positive laws which preserve the general principle of normative order. And the exercise of all public power must find its ultimate source in legal rules. So the relationship between the state and individual citizens needs to be mediated by law. Looking at the Imperial Tobacco case, the key point here is that advocates tend to read into the principle of rule of law anything which supports their particular view of what the law should be. But that is not the rule of law, of course. So moving straight ahead to constitutional interpretation, courts generally consult, and this is reflective of Drager's modern principle of internal and external aids for interpretation, but they consult the preambles and legislative statements of intent, the language and internal organization of the document. They look at legislative debates and the legislative history, committee proceedings, the overall context in which the particular enactment occurs, such as the legal context and the societal context. They look at unwritten constitutional norms and principles, and the historical, social, and political background about which the judges are either informed by expert evidence or, in the case of very well-known and widely accepted facts, take judicial notice. So when some things are so widely accepted, they don't need to be challenged in any way, then this is judicial notice. And this is a contextual interpretation. So to sum it up, we're looking at the words used, the legislative history, the legislative context, the preamble and the legislative intents, the unwritten constitutional norms and the context. It's worth noting that the Constitution of Canada is made up of the law of the Constitution and the constitutional conventions. The conventions aren't law, but they are binding. And the law of the Constitution is made up of the statutory and constitution documents, as well as the common law. So constitutional interpretation, we take a contextual interpretation and we apply it to the case of R versus Blais, and this is the issue of whether we should interpret Indians to include Métis in the National Resources Transaction Act. Blais was caught hunting out of season on Crown land, which is totally fine for Indians according to the NRTA, but he is Métis. So, do we interpret the word Indians to include Métis? Now, in the historical context, Indians and Métis were recognized as different groups. The Métis were called half-breeds, and the Indians were called Indians. And if we look to the language of the NRTA, the common usage of Indian excludes Métis. In fact, the part of the Act that refers to the ability to hunt is under Indian reserves, which is referencing the relationship between the government and the Indians according to the Indian Act, which is just relating to Indians, not relating to the Métis. The objectives of the NRTA were with respect to the obligations between the obligations to Indians as per treaties and the Indian Act. However, so if we take an originalism interpretation, Aboriginal peoples, as per the Constitution Act, are recognized as distinct from the Métis. But that's only using an originalist interpretation. If you move to step 3 there, the living tree principles says that we need to anchor this analysis in a historical context. So the Métis should now be considered Indians. And they also argue that any ambiguities in statutes should be resolved in favor of the Aboriginals. The courts in this case think that the living tree, if they use that principle and add the Métis into the NRTA, that they are creating new obligations and they're not permitted to do this. They also think that if this act were resolved, this ambiguous part of the act were resolved in favor of the Indians, they wouldn't include Métis because that would lessen the value of their hunting rights. So, so basically it was decided that the Métis should not be included in the NRTA by an originalist, and also looking at it from a contextual perspective. It was noted, however, that there is really no difference between this and the Constitution, and I guess it was noted by McAvoy that the decision by the Supreme Court was wrong, and that this is a living document. It is a negotiated document. It is not a statute, and I guess it is a statute, but it is negotiated as the Constitution was, and thus the Living Tree Doctrine should apply, and that you can create new obligations. So a note in this case is the Law Society of Canada versus Kapinker, and it's just important to note here that the preamble of the Act shall be read as part of the enactment. However, the marginal notes and historical references are not. An even further side note, the cross-headings of the Charter are deliberately included and an integral part of the Charter. So preamble and the cross-headings of the Charter are part of enactments. The marginal notes are not. Another note, can you use the Interpretation Act to interpret the Constitution? No, you can't enact a statute in order to limit what the Constitution says. The Constitution is supreme. You can't alter it by statute. So R versus Blay is one example of contextual interpretation. We're looking at the next one, the redefining of marriage, and the Parliament sent to the Supreme Court the question of, is the proposed act within the exclusive legislative authority of the Parliament of Canada? And the proposed act was to change the definition of marriage to same-sex marriage. Now, according to the Constitution, the feds are responsible for marriage, but the provinces are responsible for the solemnization of marriage. So there is a difference here, but the court did decide that changing the definition of marriage is absolutely within the head and power of the federal government. There were some arguments, though, against changing the definition to same-sex, and the arguments were that marriage is pre-legal. So looking at a very broad context, the idea of marriage is a pre- or super-legal concept that is derived from Christian belief and has been around for centuries. However, the court decided that marriage is now a civil institution, and they looked at the next argument against it, which was same-sex marriage is outside the natural limits of marriage, and they decided that the marriage is the union of two people to the exclusion of others. It has nothing to do with the sexes. That is the natural limit of the civil institution of marriage. And it was argued that the intention of the framers should be respected, an originalist interpretation, and they decided no, we need to look at the full context here. We need to use a contextual interpretation and decide what the the dominant or the what is the dominant idea of marriage, and they decided that it was the union of two people to the exclusion of others. So that is all I have to say about interpretation. It links nicely with the interpretation of learning in criminal, and it's all based on the context and the many internal and external aids you can use to decide what is constitutional, what falls within what head of power, and what the words actually mean. Another helpful point in deciding what the words actually mean and whether it's constitutional is looking at the pith and substance. So this is deciding what the dominant matter or feature of the legislation is, and this is to decide the constitutional validity with regards to whether the provincial power or the federal power can enact this legislation. The first example is Union Colliery versus Bryden, and the issue here is that no Chinaman can be employed by the mine. The pith and substance of this act was, it was supposed to be regulating mining, which is of course within the provincial jurisdiction, but the act of regulating the rights of an unnaturalized person was, I guess, in pith and substance, a federal matter. They're responsible for naturalization and aliens, and so it is a federal jurisdiction. So though related to mining, the pith and substance of the act was related to the naturalization of aliens, and this is a federal matter. Moving on to the Big M Drug Mart. So is the Lord's Day Act unconstitutional? Now, in deciding whether it was unconstitutional, first they looked at the purpose of the act, and according to Section 2A of the Canadian Charter of Rights and Freedoms, it was unconstitutional. They didn't even have to look at the effects of the act, though it was mentioned that that would be part of the test. If the purpose was constitutional, were the effects constitutional? And it was unconstitutional because it required a certain day of religious observance. They did mention, though, that you could do something like this if it was a secular day of rest. And that's exactly what they did. So who would have the power to enact this? The federal government. And I'm just going to look up why that was. So, it was found that the act is a safeguard for public morality, it's a matter for the criminal courts, and thus the Alberta government can't, it doesn't fall under the provincial jurisdiction according to the Constitution, as well as the fact that its purpose was counter to the Charter. Moving on to Canadian Western Bank versus Alberta, the question here is whether banks, which are federally regulated institutions, must follow provincial regulations regarding the sale and promotion of insurance. So, what is the pith and substance of not only the provincial act, but also they kind of looked at the dominant purpose of banks. So, the Constitution Act says banking is a federal matter. What comes within the legitimate business of banking is a federal matter. They mentioned that there are four pillars of the Canadian financial services industry. Banks, this is the only one that is federal. There's also trust companies, insurance companies, and security dealers. Now, banks have managed to convince the government along the way to blur those lines and let them sell insurance, etc. So the provincial legislation says you have to provide certain protections when you're selling insurance. But the federal government doesn't say that. So the bank here is arguing paramountcy. If the federal government doesn't say it, and they're the paramount law, then we don't have to follow your provincial legislation with regards to our insurance selling here. Now, pith and substance, the pith and substance is the true purpose of the legislation, the dominant purpose versus the merely incidental effects. Turning to the pith and substance of banks and the federal jurisdiction over banks, insurance is incidental. If the federal government said the primary purpose of the banks is to promote optional insurance, then their promotion of insurance would be a federal matter. But because it's not, because it's an incidental purpose of the banks, we're now dealing with civil and property law, which is the province. Thus, the Alberta Insurance Act applies. So the dominant purpose of the legislation will affect whether or not it is constitutionally valid. That's the main point there. Necessarily incidental. So here we have, the idea here is the ends of section 92 and 91, where if a class falls in 91, it is excluded from 92 and vice versa. So if something is a provincial jurisdiction, then it is not a federal jurisdiction. If something is a federal jurisdiction, and then it's not a provincial jurisdiction. And that's according to the Constitution, but this is generally ignored in favor of what's called flexible federalism. And this is because of the complex society we live in and the incidental effects of legislation, provincial and federal. So, and this is rather than the pith and substance. So you've got the dominant purpose, and then there are incidental effects. And the incidental effects can wade outside the legislature's jurisdiction. So there's an overlap of 91 and 92 that can be allowed. Now, minor intrusion is known as a functional relationship if some other aspects are met. A medium intrusion may be declared necessarily incidental, and there's an interesting test for this. The test does vary based on the intrusion, and the purpose of the test is to find the appropriate balance of constitutional power. So how far can the incidental effects wade into the other jurisdiction's powers? And the test is to determine whether the provision can be viewed as intruding on provincial powers, and to what extent does it intrude. So does it intrude, and if it does, to what extent? Next, we need to look at, is the act valid in the sense of its regulatory scheme? So if the act isn't valid, then there's no need to look at whether the intrusion is acceptable or not. But if the regulatory scheme is valid, then we need to know whether the questionable provisions, the intruding provisions, can be upheld by virtue of their function within the regulatory scheme, whether they're necessary for the enactment of a law that in pith and substance is within the jurisdiction of the head of power that's enacting it. So looking at it in relationship to the whole regulatory scheme. So note here that the provisions, relationship to the scheme of the regulation, and the seriousness of the intrusion are considered. So we're looking at how serious is the encroachment and its relationship to the scheme. Now, if the intruding provision passes these tests, it's declared intra vires, and depending on the intrusion, necessarily incidental, or it may be declared to be functionally relational. So a good example of this is GM versus Canadian National Leasing. Can the federal government, in legislating commerce, intrude on the provincial government by creating a civil cause of action? So property and civil rights are provincial. If the government is legislating around commerce, which they're perfectly able to do, can they create a civil cause of action? Do they have the jurisdiction? Okay, so the first question is, do they have the jurisdiction to legislate around commerce? Yes, absolutely. Pith and substance, the Combines Investigation Act, regulating anti-competitive conduct is 100% constitutional. Now, is the section of the Act that creates the civil law of action constitutional? Well, we need to follow the test. Does it intrude? Yes, but the court decides that it's a remedial intrusion and limited in general scope. And this has happened before. Next,